The L1 visa is called the executive transfer visa or intra-company transfer visa. And the important thing to remember when we think about an L1 visa, it is not an investor visa, even though there might be some investment of capital. It really truly is an employment visa. And therefore, the basis of the visa is actually an employment offer. Now, let me explain. The L1 visa requires two things. First of all, it requires a foreign affiliate and a U.S. subsidiary or related company. Because it is an intra-company transfer visa, the idea is that the beneficiary of the visa, who is already working full-time in the foreign company, wherever that may be, either as an executive or a manager, is going to be transferred with the L1 visa to come to the United States and develop the U.S. enterprise that is affiliated with a foreign parent company. So therefore, we call it an expatriate or intra-company transferee visa. Think of companies like Shell or companies like Exxon that have global operations, and they're moving people around. They're moving executives and engineers and technicians and managers from one country to the United States. Think of that as the basis of the L1. That's not to say that a small company couldn't use the L1. L1s are routinely used by large global, multi-global companies for moving talent around, but it is also used by privately owned companies or smaller companies that want to expand their operations into the United States and come take advantage of our market. And therefore, they need to send maybe their principal CEO, their principal manager, or a high-level executive to come and direct and develop the U.S. affiliate. The basic requirements for the L1 visa is A, having a foreign affiliate of which the beneficiary is an executive or a manager. That has to be there. That foreign affiliate, or we call it the foreign parent company, has to have certain characteristics. It has to be the type of company that would logically be able to expand operations in the United States. So we ideally want to see a healthy company. We want to see a company that has employees and certain staffing levels. What I always tell people is we want to see a pyramid organizational chart. So there's a head of the company, maybe an intermediary manager level, and then subordinate employees. So when that top of the company person moves to the United States with the L1 visa, once it's approved, the company abroad can continue to operate. That's the main thing. So that would eliminate maybe mom and pop shops or small companies that just don't have people that will run them. So we have to evaluate the foreign company meets those requirements. That's part of the assessment. The second condition or requirement is that there'll be a U.S. company established to do something in the U.S. Now, that something or that business doesn't have to be exactly the same business as the foreign parent business abroad. It could be a completely separate business. For example, the foreign parent company may be in the oil and gas business or plastics business or food business, and it can come to the United States on an L1 visa, establish a company to do something completely different than what it was doing in the home country. It could be the same or it could be different. It really doesn't matter. But the U.S. company has to do some kind of business. Now, it's very important people understand, and it's a little difficult to explain in a short video, but the company, foreign company, and the U.S. company have to be connected. There has to be a corporate connection between the two. There has to be control by the foreign company on the U.S. company side, and there's many ways that lawyers can arrange for that. That would require a deeper consultation, but there has to be a connection between the two. One has to be the affiliate or subsidiary of the other, and there's different ways we can get there. The third requirement is that the beneficiary, the L1 visa person, that person needs to have worked in the foreign company for at least 1 year, continuous year, in the 3 years preceding the application. So we look back at 3 years. Any of those 3 years, 1 year working in the foreign company as an executive or manager. We have to prove it with documentation. And then the idea would be that that person would be transferred to the US subsidiary to then assume also an executive or managerial role. Those are the three main requirements for the L1 visa. Well, the benefits of the L1 visa: A, the L1 beneficiary will get a job with the US affiliate, will be able to work only for that affiliate. He can have spouses and children follow him on L2 visa status. The spouse has authority to work in the United States once we get an employment authorization application process for them. All of them get Social Security cards, and with that comes all the benefits of participating in our society and our economy, like driver's licenses, credit, loans, participating in health insurance plans, etc. So essentially, you're coming temporarily to the United States. The L1 visa has a total maximum authorized validity or stay of 7 years in total. You don't get 7 years at once. You get it in increments. Normally what we do is, to start the L1 visa, is we meet with the beneficiaries and or the representatives of the foreign company. That could be the same person, it could be the owner or owners, or it could be an employee of the owners. Because we need the cooperation of the company abroad. We're gonna have to get documentation from that company, so we wanna make sure that they're willing to do so. And if we're talking to the owner, of course, that's the person we're talking to. We're gonna ask for some basic documentation to ensure that the foreign company indeed is qualified. We don't want to start it if they don't qualify. Then we're going to request some documentation of the beneficiary. We want to make sure that we can prove that the L1 person that's going to get the L1 visa actually can prove that they work in that company. Because believe it or not, some people own companies but they don't work there, right? They could be passive owners, family members. So we want to make sure we can prove that. The last thing is we need to evaluate what the plan is for the US operations. We want to make sure that the company in the US will be operational, will be functioning, will enable us to extend the beneficiary more time, and hopefully create employment. The company in the US has to generate further employment, not just you, more employees, so we can justify an extension of time. Most L1s that fail is because they fail to create the required employment. There's not a magic number. We don't have a magic number of employees. It really depends how many employees you have to create. It really depends on the nature of the business. You know, some companies need a lot of employees and justify having them because that's what they require. For example, nail salon, a restaurant, a manufacturing facility, whatnot. But some businesses don't require that many employees. So it really is a case-by-case basis. The key here is that you're actually creating the employees. I really think that, again, any business, I would suggest, the perfect business for an L1 visa is one that will create employment. So if your intention is to establish a company in the United States and use the L1 visa, for example, it wouldn't be good for you to come and create a consulting company and you only have 3 people working there because that's all the company requires. That wouldn't be a good idea. You probably won't get renewed. You might get the first visa, but I probably can't guarantee you that you will proceed to the next step. Restaurants, like I said, manufacturing facilities, call centers, stores, retail, wholesalers. That's the kind of business that's ideal because it does generate employment. And it generates management employees. So that's what we want to see, because then you're going to be in a better situation to move on to perhaps the green card option of the L1, which is the EB1C. The L1 is one of those visas that has an open door. It leaves the door open to obtain a green card through this scenario of foreign US affiliate. This visa is called the EB1C and it's called the multinational manager. And it's essentially an L1 with a green card. L1 is temporary, maximum stay 7 years. Hopefully we can renew and extend you. And during that period of time, After the first year, we can consider whether you qualify for the EB1C green card. Why? Because although on paper, when you look at the qualifications and requirements of the EB1C, looks just identical to the L1, but in reality, it is not treated like that. It's like an L1 on steroids. The level of scrutiny and the standards applied to it by the government are much higher than a traditional L1. So we want to make sure we have a solid company with solid growth and solid staffing before we move to the green card, but it is entirely possible. The L1 is a wonderful visa if you understand it. I think a big deal is to make sure the client, that you understand how it works and how it progresses. I see many people starting on L1 visas and they don't fully understand them. And then they're disappointed that they can't renew them or extend them. I think following our counsel and our advice is very important, and that you understand from the get-go what the requirements are so you can then live up to them. If you do that, you won't have any problem, and you'll be able to graduate into potentially getting a green card for yourself and your family through your own employment. Thank you.